AI chatbot become your therapist? Imagine a system that listens to you, analyzes your emotions, and offers personalized advice day and night when you're feeling low or anxious. For many people, this is already a reality. But when that system begins to act like a therapist, does it become a medical device? And if something goes wrong, who's responsible? I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper, and this is Diritto al Digitale, the podcast where we explore the intersection between law and innovation. Today we dive into one of the most sensitive and fast-evolving topics in tech law, the legal responsibilities of artificial intelligence tools used for mental health and psychological support. Are they wellness apps, or are they in fact digital medical devices? And what happens when the line between the two becomes blurred? Over the past few years, AI-driven assistants and chatbots have started to play an unexpected role in emotional well-being. Generative AI models can now simulate empathy, interpret mood patterns, and respond in a tone that feels almost human. However, this technological sophistication brings legal complexity. The key legal question is whether these tools remain in the wellness domain or cross into medical practice. Because once an AI performs a therapeutic, diagnostic, or monitoring function, it may be qualified as a medical device, triggering the full set of regulatory and liability frameworks that apply under the EU Medical Devices Regulations, also named as MDR, and potentially the EU AI Act for high-risk systems. From a legal standpoint, qualification depends on purpose and functionality. Let's look at the two critical tests. Declare purpose: if the AI claims to improve mood, diagnose depression, or guide therapy, that purpose already points to a medical intention. Actual functionality: even if not declared, if the AI analyzes symptoms, monitors user behavior, or recommends treatment, regulators may still classify it as a medical device. In the EU, such systems would need to be marked with the CE certification, would need clinical evaluation, and post-market surveillance. And under the EU AI Act, these systems would almost certainly fall under the high-risk categories, requiring transparency, human oversight, risk management, and documentation. For technology providers, this means one thing: non-compliance is not an option. Operating an uncertified AI that performs medical functions could expose developers and distributors to civil and even criminal liabilities. This is not just for those that create the LLM, because even if a company is using an LLM produced, manufactured by a third party, but it's embedded in its own product that is marketed with its own trademark, then the entity using this technology might be qualified as a provider under the EU AI Act. When AI is used for psychological support, several legal issues emerge. Number one, liability for harm. If an AI provides misleading advice that worsens a user's condition or delays treatment, who bears responsibility? Manufacturers, integrators, healthcare professionals relying on it? Courts may apply a duty of care standard similar to medical negligence, requiring that products are safe, instructions clear, and risks disclosed. Number two, transparency and user information. Users must be informed that they are interacting with an AI system, not a human therapist, and that the tool cannot replace medical supervision. Failing to disclose this could constitute misleading commercial practice or even breach consumer protection law. Number three, data protection and sensitive data-related issues. Mental health data is among the most sensitive under GDPR. Processing emotions, voice patterns, or psychological states demands explicit consent, strict minimization, and strong encryption. Profiling and retention policies must also be legally justified. Number 4, issues relating to biases, fairness, and algorithmic transparency. AI trained on limited or biased datasets may produce discriminatory or unsafe outcomes. This raises potential liability for defective design or negligent testing, especially when affecting vulnerable individuals. The last issue relates to ongoing monitoring and post-market controls. Under the MDR, manufacturers must conduct post-market surveillance. For AI, this includes algorithm updates, performance monitoring, and reporting of adverse events, an area still lacking clear guidance but essential for compliance. The psychological support challenge is open. AI used for psychological help poses unique ethical and legal tensions. Number 1, emotional attachment and dependency. Research shows users can form strong emotional bonds with conversational AIs, even seeing them as companions. This can lead to dependency or emotional harm. Another issue relates to unauthorized practice. If AI simulates therapy, it might constitute unlicensed medical practice. An additional issue relates to crisis response. What happens if a user expresses suicidal thoughts? Is the AI trained and legally obligated to react appropriately? And the last issue relates to vulnerable users. Children, divergent individuals, or patients with mental disorders may require additional safeguards and human supervision. The intersection between AI ethics, mental health regulation, and product liability is becoming one of the most complex frontiers of digital law. That's why if you are advising a startup, or if you are a startup, or if you are a company deploying such systems in healthcare, or if you are a company trying to embed these solutions in your product supplies, here a practical compliance checklist. Number 1, qualification analysis. Then determine if your AI qualifies as a software, as a medical device. Number 2, risk assessment. Map all possible harms, psychological, data, or systemic, and document mitigation steps. Number 3, user transparency. Introduce clear disclaimers that AI is not a therapist, plus emergency contact procedures. Number 4, issues relating to privacy and cybersecurity. Integrate privacy by design, limited data retention, and secure data flows, and test the system to make sure that adequate security measures are in place, together with policies and procedures to react to potential cyber attacks. Number 5, clinical oversight. Involve licensed professionals to review outputs and mitigate misuse. And then we have post-market monitoring, implement reporting channels, audits, and traceability. Also, you need to consider when you are contracting the product to the benefit of third parties, you need to define liability allocation, warranty limits, and insurance coverage. And you need to monitor the evolving AI Act, the MDR, and national health regulations that might change very quickly, especially in this transitional phase. The open question for the future are, when exactly does emotional support turn into therapy? Could AI-based psychological tools require a human in the loop by law? Should regulators create a new category of digital therapy apps? How will courts evaluate causation and damage in cases of emotional harm? And finally, can a machine ever be truly responsible for a human mental health outcome? These are questions that will define the next decade of AI and health law. As legal professionals, we must help shape this framework, ensuring that AI can power users without compromising their safety, privacy, or dignity. The boundary between wellness and medicine is fading, and law will be the line that keeps it ethical. If you find this episode insightful, I'd love to hear your thoughts. Write me an email at giulio.coraggio@dlapiper.com and subscribe to the podcast Diritto al Digitale and activate the bell so you don't miss our next episodes. And if you enjoyed this episode, please leave us 5 stars on Apple Podcasts or Spotify. It really helps others discover the show. I'm Giulio Coraggio and this is Diritto al Digitale. Arrivederci.